Now the last topic is mental health and death penalty. The net zero emission is over, and this is the last point which I will discuss in this lecture. Mental health and death penalty. It is also mentioned in some editorial recently, I guess in last week itself. It was in the Hindu. It talks about the mental health and the death penalty which are being imposed in various countries, and many countries have banned the death penalty in their national laws. So what was the news? Let's discuss. Now there was a report by Project 39A of NLU Delhi. What was the report? Death Worthy, a mental health perspective of death penalty. Now it explores, this report explores the mental health concerns of death row prisoners and the psych impact of being on death row. This report basically covers the mental health concern of those prisoners who are getting punishment of death penalty. Now they have been waiting for this through many years. Now the psychological impact of these things are very higher. So the report talks about the same, that what are the mental concerns, what are the health concerns with respect to death penalty. There are many prisoners who are waiting for 10 years just for being hanged in some time or other. So what are the concerns with respect to this? Now United Nations Human Rights Commission, it said that not to impose death penalty on persons suffering from any form of mental disorder or to execute any such person. Now UNHCR, United Nations Human Rights Commission, it said that you can't impose death penalty to those persons who are suffering from mental illness. They're not getting an idea about what will happen to them. They are mentally not stable. So you can't impose death penalty on those prisoners who are getting these kind of things. Now, what are the report talks about the concern with respect to this. Now, if you are giving death penalty to those persons, it jeopardizes the right to a fair trial of our constitution. Right to fair trial is given in our constitution. Now, for example, when a prisoner is facing a mental health problem, they can't have a right to fair trial because they can't really help their own lawyers to defend themselves in court. They can't state the actual fact which was being happened because cases do travel years and years in the court. So it hamper the right to fair trial of our constitution if we are giving death penalty to those prisoners who are getting mental health concerns. Now, death penalty, capital punishment is the term used. So what is capital punishment? Capital punishment is the execution of an offender sentenced to death after conviction by a court of law of criminal offense. Right? So it is the highest penalty awarded to an accused. It is the highest kind of penalty. You will get imprisonment for 7 years, 14 years, but capital punishment is the highest penalty awarded to an accused. You can't give more than some punishment with more than death penalty. It is awarded in extremely severe cases of murder, rape, or we can say it is awarded in rarest of rare cases. That's it. There was a case which talks about the guidelines with regard to death penalty, capital punishment, and which says that death penalty will only be awarded in a rarest of rare cases. I'll talk about the case in the further slide. Now, when you give capital punishment to an accused, the morality of death penalty is very debatable. Right? Who will get death penalty? How you will get death penalty? If I murder one person, will I get death penalty? Or if I murder 4 persons, will I get death penalty? So this thing is very subjective. The morality of death penalty is very, very, very subjective. You can debate on this for like many years to come. So next is the morality of the death penalty is quite debatable. Like for example, if I murder a person, will I get death penalty, or will I get death penalty when I murder 2 or 3 persons? Or what kind of offense I will commit to get a death penalty, right? So this is very debatable. Even if you say that death penalty will be given to rarest of rare cases, what is the rarest of rare cases is also very subjective. Some court will say that this is the rarest of rare cases, some other court will say this is the rarest of rare cases. So that's why I'm saying morality of death penalty is very debatable. It will depend on one person to person, that's it. Now, talking about arguments in favor of death penalty, right? There are 4 arguments that are in favor of death penalty. Now, what retribution means? Retribution means people should get what they deserve in proportion to the severity of their crime. This is the first argument that is in favor of death penalty. Like, if I murder a person, the retribution says that I'll deserve again the murder of I'll be murdered somehow, because this is what I deserve, because in proportion to the severity of my crime. Like, if I murder a person, I'll get murdered for the same. So this is retribution first. Second is deterrence. What is deterrence? The act of discouraging an act event through instilling a doubt or fear of the consequences. So the basic example is this, that deterrence works in this way, that if I commit a crime, now court will set an example by hanging me to death, so that people will get to know that okay, if you murder some person, you will get death penalty. So instill a fear in the general public, in the general society, that no, we don't have to commit these kind of offenses. So deterrence work this way. This also has a counter argument which I'll discuss in the next in against. Then the third argument is it provides closure for victim families. Now again, for example, it provides closure for victim families. If you murder a person, the families of those the family of that person, the family of the victim will get closure after you'll get a death penalty, or will get punishment for the crime you deserve. So this is again the third argument. Now last is it lead to some form of rehabilitation, right? Thomas Aquinas, you don't have to mention it. He's a philosopher, he's a social thinker. So he said it lead to some form of rehabilitation. Now arguments against. Now you know the arguments in favor of death penalty: retribution, deterrence, closure and all. Now the counter arguments against the death penalty are: statistical evidence doesn't confirm that deterrence works. Deterrence, the act of discouraging an action, instilling a fear. Now statistical evidence does not confirm that this thing works in the society. For example, again, death has been prescribed in rape cases since 2013. Still it continues to happen. Agar deterrence work karta, then I don't think rape cases will happen if this thing work. Now the statistics shows that death has it is still prevalent in the society. Rape are being happened in the society. So it shows that it doesn't work anymore in this society. It doesn't work. Next is risk of executing the innocent cannot be eliminated. Like if an innocent person is hanged, if an innocent person is prescribed, if an innocent person is being hanged to death, if he is being accused of murdering someone, and he'll get an order with respect to this, that he'll get a death penalty. Now the risk of innocent, ये eliminate आप कर ही नहीं सकते, because there are many cases where innocent people are in jail, and lots of non-innocent people are in your society. So this is the risk involved in the death penalty scenario, that you can't eliminate the risk of executing an innocent person. Next is retribution is immoral. It is a just form of vengeance, right? It is very true. Retribution is immoral. Now, what retribution I said? I should get what I deserve. People should get what they deserve in proportion to the severity of their crime. So actually, it is a very sort of a revenge type of thing. It is very immoral. So this is the argument. Next is it does not rehabilitate the prisoner. It is very logical argument here that it does not rehabilitate the prisoner. How will you rehabilitate the prisoner if you hang that person to death? He won't get rehabilitated, right? You are not actually looking at the person in heaven that he will get rehabilitated there, right? His life is gone when you awarded death penalty to that person. So that's what it is. It does not rehabilitate the prisoner. Next is death has been abolished in most of the developed countries. Yes, there are many countries which abolished the death penalty, and these are very developed countries also. So that this is also a very logical argument in against death penalty, that there are countries which are developed and they abolished this sort of penalty to an accused, right? This will come into the question. That's why I'm not giving you the answer which country abolished death penalty. Now again, coming back to the Indian context, right? Now section 354 clause 3 of CRPC. CRPC is Criminal Procedural Code. You will get to know these things when you get into law school, but here just have a basic idea that section 354 clause 3 of CRPC, it says that courts are required to state reasons in writing for awarding the maximum penalty. Now when you it says that if a court awarded death penalty to a prisoner, to an accused, then the court have to state the reason in writing for awarding the death penalty. What are the reasons? Why are you giving death penalty to an accused? So this is mentioned in section 354 clause 3 of CRPC. Then there are case law. I told you Bachchan Singh versus State of Punjab, which was in 1980. In this case, Supreme Court propounded the rarest of rare cases. Supreme Court said that the court will award death penalty to only those cases which are rarest, or which are called as rarest of rare cases, only to those crimes. So Bachchan Singh is the case. This is very important for you with respect to GK and also legal point of view, because NLUD or even BLAT can ask these type of questions, because death penalty is in news. So the static part comes back to this. This is the static part of GK. Now, when the murder is committed in an extremely brutal, ridiculous, revolting manner so as to awaken intense and extreme indignation of the community, it is the rarest of rare cases. It is just a basic definition of what is the rarest of rare cases. You don't have to remember this definition, but just have an idea what is rarest of rare cases. So there are some keywords in every definition you have to focus on. Just focus on keywords and it works in your exam. It will work on in your exams. Like extremely brutal, first. Revolting manner. Awaken intense and extreme indignation of the community. Society में, community में, ये सब हो तब. So when the definition is this, then again in the second case, it's the court says that mental illness should warrant the commutation of a death sentence to life imprisonment. The court says in this case that if a prisoner, if an accused have a mental illness and the death penalty have been awarded to that person, then the death sentence will come back to the life imprisonment. It will commute to life imprisonment, because you can't, just like I said, you can't give death penalty to a person who is mentally unstable. The basic fundamental right is being violated in this, right to a fair trial, which is being enshrined in our constitution. So you can't violate fundamental rights, right? A court is the protector of these rights. So, and next is, in inhuman condition case, Supreme Court recognized that every prisoner with mental illness has a right to live with dignity. Again, these are right, you just focus right to live with dignity. Now again, question can come, right to live with dignity is covered under article, which article? So that's how question formed in exams, right? There are current aspect. You will get for example, I'll give an example. You'll get a comprehension related to death penalty and mental illness. Okay. Now the question will come straight from this. The editorial will definitely mention that right to fair trial, right to live with dignity is being hampered, and all. Then again, when you go into the question pattern, question will come like right to live with dignity is covered under which article of our constitution, right? So this is how question forms. Now in conclusion of this death penalty, court says that you have to take psychosocial approach. You have to think about the psychological aspect of the accused, and the social approach also must be recognized, that what will happen to that person who are having mental illness and are being in a death row, right? So you have to take psychosocial approach. Second is intellectual disability. Intellectual disability here means that the people who are in death row and are facing mental illness, they don't have the intellectual ability to contact their lawyer. Like I just said, they can't contact their lawyers in a very sound manner, right? So that's how it forms that there is a lack of intellectual ability in those prisoners. So that's what even report also mentioned. Next is social determinants of mental illness should also be considered. And then again, right to fair trial, because it is being hampered in cases where death penalty has been awarded to those accused which are facing mental illness, right? Now coming back to the question, and this is the last slide. Of my lecture. Coming back to the question. Now, right to fair trial is included in Article 21. This is the answer. Headquarters of UNHCR. UNHCR is very important because it talks about the human rights and all. So you can expect question headquarters of. Earlier also, these exams have asked the headquarters of those conventions or headquarters of those important institutions, international institutions which are in news. So headquarters of UNHCR, Geneva, Switzerland. Next is, which is the first country to abolish the death penalty? Like I said, Venezuela in 1863 was the first country to abolish the death penalty. And who's the most recent country to abolish the death penalty? Sierra Leone, 2021. It is also very relevant because it is in news, because it has happened in 2021, so it is relevant for you to study this and for your exam in 2022. And last is right to dignity is enshrined in, again, Article 21. So right to fair trial and right to dignity is enshrined, both are enshrined in Article 20. Article 21 is basically a very wider article. The ambit of this article is very wide. So even the recent right to privacy, which was propounded in Puttaswamy judgment, case Puttaswamy versus Union of India, Puttaswamy judgment. So right to privacy is also included in Article 21. So everything the news comes, it is so yeah. Right to fair trial, right to dignity, both are being included in Article 21. Also, just remember, right to privacy is also included in Article 21. Just a bonus fact. That's it.